Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this particular episode, I'd like to continue with my updated series on EB-5 investment visas. I'm breaking it into a few different parts so that you don't get bored with one big video. And some of the updates are based upon new regulations or updated regulations or interpreted memorandum of the regulations, basically provisions of case law in the ever-developing EB-5 world and what's going on. So in this particular episode, I'd like to talk about basically a couple different things. First of all, I'd like to talk about the path sometimes to get here quicker. And this is if you're going to be investing in your own business, and if you come from a country that allows what are called E-2 treaty investor visas. So if you come from a country that involves or where you can get an E-2, you come here, you invest 100,000, 200,000, whatever it is, get the E-2, and then you start investing more as the years go on, so that you get up to, if it's in a targeted employment area, the 500,000 investment, or if it's not, the $1 million investment, and then you can apply for a change of status from or an adjustment of status from the E2 to the EB-5. Unless, of course, you're from China and there's a several-year backlog and there's nothing available. But if you are from a country where it is available, then you do the E2 to the EB-5. So the E2 gets you here relatively quickly if it's done properly. You know, your spouse, your children who are single and under 21 come here. And the issue, though, with the E2 and the investing is you cannot use retained earnings in which to show it's part of the investment. So what do I mean by that? Let's say that you sell gum, whatever it is, and let's say that in the first year you came, you made $1 million of profit selling gum, and you took $200,000 of that profit, put it back in the company to hire more employees, get more equipment, make more gum making machines. You cannot use that $200,000 you just put back in the company in which to consider that as part of an investment or part of the funds needed for an EB-5 investment. They need to essentially come from your pocket or from gift or from the normal ways that an EB-5 is done. So if you start off relatively small with $100,000 or $200,000 in an E2 company, you later just invest the normal way to expand the business to get to the proper amount, and then you can go to apply to an EB-5. So it's not that the E2 becomes an EB-5, it is that the E2 can lead to you applying for an EB-5, and that again is for you, your spouse, and your unmarried children under 21. Okay, now there's another issue, another part of the EB-5 which is critical, that this is not done, which will result in a denial. There's not even a question. It will result in a denial. And so at all costs you want to avoid the following. Now, an investment means that your money is a risk. Okay, if your money is not at risk, then it's not an investment as far as immigration is concerned, especially under the EB-5. It'll be denied. So how is that possible? Well, one, you could have a redemption agreement. You might get a redemption agreement because let's say that some company, some regional center, and this applies whether it's a regional center or your own direct investment, says, and they want your money, right? They want your 500,000. So they go, we will redeem your money and give it back to you 3 days after the IA-29 is approved. Okay. If they do that, then that means your money's not at risk because it's a redemption agreement. You're going to get it all back, and it'll be denied. And let's say that you have a 50-page agreement that has all kinds of legalese in there and has every kind of provision under the sun. And there's on page 32, paragraph 4, and the 6th word, it says redemption. even if it, basically makes it so that that it's unlikely you'll get redeemed, or even if it says there is no guarantee of a redemption of your money. Um, in my opinion, you ought to make sure that the word redemption or redeem or anything that leads to the conclusion that there is a redemption agreement will be removed from any agreement that you have. So, obviously, you as the investor may want to read all the documents, but certainly have your lawyer read all of the documents. If it's a regional center, have them look at the business plan, at everything else in which to make sure that there are no redemption agreements. Now, the next thing is there can be no guarantees, none. Okay, they can't say we are guaranteeing that you will get a 5% interest rate on your investment. Okay, or we are guaranteeing that you will get your money back at some point in the future. Anything that is guaranteeing any part of that money that you're investing will be considered a violation of EB-5 regulations and will basically indicate that the money is not at risk. Okay, so very, very important. Um, Make sure there are no redemption agreements, no guarantees of any kind. Now, I know that as an investment, you want to have that. Okay, obviously, you would love to have that. And if you were investing in a real situation, a real company, you might, full well demand a redemption or some type of guarantee, but not with the EB-5. EB-5 is the opposite. If your attorney's on the ball, your attorney will say, get the guarantees out of the agreement, get the redemption provisions out of the agreement. Okay, and then that will show that the money's at risk. And then you may get your money back. You may get it back with, some very small percentage rate. You may get some of the money back, but all that will happen based on the agreement and if certain things are met, but there's no guarantee and no redemption. Okay, if you like the video, click like. Email me if you want to get a consultation. More on the coming videos.